So the first question is, why would you bother making a will? I'm often asked this as many clients tell me that their affairs are so simple that they don't think it's necessary. Often I go on to chat with them about their family situation. These situations can be quite straightforward or rather complicated. Separations, remarriages, stepchildren and cohabitants are now very common. It may well be that you'd be happy for your assets to be distributed according to the law of intestacy, which is the situation when you die without a will. You do, however, need to be clear as to what the law says in that respect with reference to your own situation. Do you know, for example, what your spouse would be entitled to if you died without a will? Do you know, for example, that he or she would only be entitled to a house, furniture and cash up to certain limits? These are called prior rights and are listed in the slide which I'm now bringing up. After payment of prior rights and legal rights, of which more later, the order of distribution is settled by reference to the Succession Scotland Act 1964. And you can see the order of division on this next screen. It might, in fact, not be quite what you expect. It's worth pointing out that if you're an unmarried cohabitant, prior rights and legal rights do not apply. Do you know that a cohabitant has to go to court to make a claim on intestacy? We don't have time to talk about all of the permutations of intestacy, but my strong advice is that if you're relying on this as an alternative to making a will, please be sure you know how it will apply to your estate. This whole area has been the subject of a review and maybe again, so be aware that changes could come in future. I would probably also say in passing that with just short of 40 years of practice, I've rarely met an adult for whom not making a will is the better option. But I'd also like to list a few other reasons why you should make a will. One of the fundamental things that it does is appoint your executors. These are the people whom you entrust to carry out your wishes and divide your estate. If no executors are appointed, then it is often a requirement to go to court to have an executor appointment, and usually you have to pay an insurance premium as well. Simply by making a will, you avoid those costs being borne by your family. Your will also allows you to leave specific bequests of items or legacies of cash. It allows you to let people know what you would like done at your funeral, and it means you can divide your assets according to what you personally think is fair. Now, fairness doesn't always mean equality. For example, if you have a close relationship with a particular niece, there is no reason why you can't leave her more of your estate than your other nieces and nephews whom you rarely see. I believe the other strong benefit of making a will is that it tells your loved ones exactly what you want. That can give huge comfort to your family, but also it means there's less likely to be any dispute amongst them. I've mentioned legal rights. The law in Scotland does provide that certain family members, namely spouses, civil partners and children, have legal rights in your estate, notwithstanding what you have written in your will. At the moment, these are claimed from your movable estate, in other words, not land and property. And generally speaking, if you're providing for those people in your will anyway, they're often not claimed, as it's not possible to claim legal rights and take the benefit under the will. However, it's worth having a discussion with your solicitor if you have a concern about a spouse or a child who might have a claim and you may not wish them to benefit in that way. Children in this context include adopted children and illegitimate children. The law doesn't distinguish between those categories. And it's worth pointing out also that the issue of predeceasing children also have a claim. And please also remember that existing wills are not revoked on marriage, and only parts are revoked on divorce. However, as separation can sometimes precede divorce, often by many years, it's always sensible, firstly, to get advice on a separation agreement, and secondly, to update your will if you part from your spouse or civil partner. Now, your will normally deals with bequests and legacies of cash before giving instructions on how to divide up the remainder, which is known as the residue. Expenses of winding up an estate are normally paid out of the residue unless the will provides differently. Wills can be simple or quite complex. Complexity often comes from specific situations, such as making provision for young or disabled family members. Also, in the case of second marriages, it's not uncommon to create what are called life rents in order to allow the partner to continue to reside in a particular property whilst preserving the ultimate value of that property for children. Life rents can be used in circumstances where each member of a couple wishes to leave their own half share to their children on first death. This may helpfully result in the survivor not increasing the value of their own assets, which, although not particularly advantageous for capital tax purposes, it can be helpful if there is a financial assessment by the local authority for the purposes of determining their contribution to care costs. I'll mention care costs later. And of course, wills do not need to provide only for family members. Many people leave bequests to charity in their wills, and it's an important source of revenue for many charitable organisations. Some people make specific bequests, others leave them a share of the residue. It's possible to consider charities as fail-safe or fallback beneficiaries too. In other words, they benefit if family doesn't survive to take the shares involved. There can be some tax advantages too if your estate is likely to be charged with inheritance tax. Wills are often part of a tax planning exercise and can be used to mitigate the effect of inheritance tax. Exploring whether inheritance tax is likely to apply to your estate and if you wish to do anything about it does very much form part of what we do when we discuss will making with you. And although inheritance tax itself is not part of today's talk, I'd be happy to answer any questions separately on that. Sometimes wills can create trusts, which can often be in the context of tax planning or other asset protection. Again, trusts themselves are a topic in their own right, but if this is something that you would like to explore further, I'm happy to discuss that separately too. So, if you want to make a will, and if you would like to use Gilson Gray to do that, there's a simple way to do so by accessing the link that I've put on the screen just now, or calling us, and I'll give you my contact details at the end. So, now on to incapacity. So we've gone through some issues relating to a will, and that sets out what happens when you die. But there's merit in considering whether you have adequately dealt with the possibility of your incapacity prior to death. Incapacity is defined as the inability to take action and make, communicate, and understand decisions. That incapacity may be due to illness or disability. However, it's not always clear when the point of incapacity has been reached. In fact, some people may move in and out of the ability to make decisions for themselves over a period of time. The crucial issue about capacity is that when it is lost, the ability of an individual to undertake certain tasks with legal consequences is lost too. That can include the ability to make a will, to transfer assets, or generally to contract. Sometimes, just at the time when action needs to be taken, the lack of capacity can preclude things being progressed. This can be tricky, but there are ways we can help if action is taken in time. Prior to 1991, it was generally not possible for powers of attorney to survive the point of incapacity. But current legislation, in the form of the Adults with Incapacity Scotland Act 2000, now means that a correctly executed deed can allow an attorney to continue to act even after capacity is lost. The clear benefit here is that a power of attorney, granted when a person has the ability to do so, can provide the mechanism for acts to be done to benefit that individual when he or she can no longer do so themselves. It's for that reason that I always recommend to clients who come to speak to me about making a will that they also consider a power of attorney. I do that irrespective of their age because, of course, incapacity is not the exclusive domain of the elderly. Illness and accident can give rise to such a situation as well, and some of the most difficult examples I have come across do indeed involve people who could not remotely be described as old. Obviously, they do come into their own in situations and illnesses such as dementia. Of course, in many cases, having prepared this document, it may be that it's never used, in which case you may be worried that it's been a waste of time, effort and money. But you might also take the view that that's a bit of a win-win situation. Perhaps it would be wise to look at the alternatives to a power of attorney. The alternative to that document, prepared as I've described, which survives incapacity, could involve going back to court again. This would be either to appoint a guardian or to have the court make other orders, such as intervention orders, which give authority to do certain one-off things, for example, authority to sell a house. Of course, anything which involves going to court is more complex, takes more time, and is more expensive, although it's worth pointing out that legal aid can be available if you're applying for welfare powers. As to what's included in a power of attorney and the steps required to put it in place, that's very much part of the discussion you will have with your solicitor. It's important you understand the process and get the opportunity to ask questions. There are two broad categories of powers, the continuing or financial powers and the welfare powers. The continuing powers are called that because they continue beyond the point of incapacity. Different people can take different powers. The key point is that whilst the continuing powers can be used with the adult's consent prior to incapacity, the welfare powers can only be used after an adult has lost capacity. I'm often asked how that's decided. Recording how you would like it to be decided is part of the process that we go through when putting this in place, and we record what your wishes are there. Generally, it comes down to a choice between your attorney or attorneys making that decision and the involvement of a doctor. Making someone your attorney is a really important step, and it is something that does require complete trust. You can appoint one or more people who can act individually, jointly, or as substitutes. There are protections in place, of course, but your choice of attorney should be considered carefully. And I would go so far as to say that, although I'm judged for that, sorry, I've lost my thread slightly. Yes, there are protections in place, but your choice of attorney is important. And I was just saying that it is often my view that no attorney is better than a bad attorney. There are certain things that can't be done under a power of attorney, and the most obvious one is making or changing your will. It's easy to get confused between the granting of a power of attorney and the making of a will. Those that you appoint as your attorneys may also be the people you appoint as executors under your will. However, it's important to remember that the powers under the power of attorney die with you. At that point, the attorney no longer has a right to act, and things then move to be dealt with under your will, if you've made one. And I'm just bringing up a little summary of what I've just been through there. Before moving away from wills and powers of attorney, I want to just briefly mention the importance of keeping things up to date. It really is important that these documents always reflect your current wishes. Some people view making a will in particular as a once-in-a-lifetime task, but this is probably unwise. Circumstances can change: marriage, children, divorce, inheriting from your own parents, accumulating wealth. A snapshot of what is relevant today may not be appropriate in 20 years' time. So my advice is always to check it over every few years, or certainly when life events happen. It is sometimes possible to make fairly minor changes to update your wills by way of codicil, or if more significant changes are required, we would normally recommend a rewrite. So those are two important documents that you should think about now, but certainly as a later life issue, it is something that everyone should have in place. I wanted to mention also briefly the question of funding care costs. This is something that I'm asked about a lot, often alongside questions relating to someone's house and how to protect it. Again, this is potentially quite a big topic, and there is no single solution, and I'm sorry to say no silver bullet. Generally speaking, if you wish the local authority to assist with funding care, there'll be an assessment of your finances. Now, if the total value of your assets is above £28,500, that's the current figure, then aside from the Scottish Government's contribution to personal care and nursing care, the local authority will not pay. However, below that, they will start to contribute on a sliding scale until the value of your assets drops below the lower limit, which is currently £18,000. Now, the assessment looks at both capital and income, but some aspects are disregarded. For example, in the case of a couple where one, say the husband, goes into care and the wife remains in the family home, half of his pension can be disregarded if it's paid to her. In addition, his commitments to the expenses of running the home can work to increase the allowance of what he is allowed to keep. And in those circumstances, the capital of the property is also disregarded for so long as she needs to live there. On the screen, I've given you a website where there's a helpful summary of all of these rules, and it's probably worth looking at that in some detail if you've got a family member who's in that situation. With regard to the steps you might consider to protect your home, we may explore one or more of the following. We can look at transferring your property outright to someone else. Often when people come to see me, they are asking about transferring their house to their children, for example. That has to be subject to huge health warnings about the risks attached of doing that. Basically, you're giving away your home, and that's quite a big step for anybody to take. The risks generally relate to the recipient of the transfer and what would happen if, for example, they were themselves to die. Have they made a will? Might they leave your home to some third party that wouldn't want you to stay there anymore? What if they are starting up a new business and it fails and they become bankrupt? The trustee in sequestration might take the house as part of that bankruptcy. Or maybe they go through a really horrible divorce and their assets are split and your home is just one of those assets. There may also be some tax trips in all of this in relation to gifts with reservation if you continue to live in the property, which in the main is the scenario that is envisaged. I would say more often than not, once I've gone through all of these scenarios with people, it's pretty rare for people to continue to want to give their home away, but not, not uniquely so. Transferring into a trust, there are some people who sell sort of packaged trust solutions in this area and suggest to people that they put their home into a trust. Now, a trust is a wrapper which can protect you against some of the risks that I highlighted there in connection with the outright transfer. But there are some downsides there as well. It's expensive to set up, usually at least a couple of £1,000s, if not more. And it does mean that there's a bit less flexibility. You're no longer the owner of the house, the trust is the owner of the house, so there's less flexibility. And specifically, it is very difficult to borrow money on a house that is in trust. Now, that may not be seen as a major downside, but some people like to use their house in order to raise some cash for, fantastic holidays or to do modifications to the house in future. And by putting it in trust, then you're effectively shutting the door on that possibility. The other thing that we do is consider the use of life rent trusts in wills to protect the share of property, and I've touched on this already. So how that works, assuming that a couple owns a house jointly, then on first death, the share that belongs to the first to die does not pass to the survivor. It goes to the designated beneficiaries at that point, but subject to the right of the survivor to continue to live in the half share of the house until he or she themselves die or want to give up the right to live there. And that's a form of trust. The benefit of that is that if that survivor is then assessed as requiring care and wants the local authority to help, then the financial assessment will include only half of the value of the house, not the whole. So it's a sort of hybrid solution which, given the pros and cons of the other possible solutions, is sometimes where people end up. In all of these solutions, we have to be mindful of the inheritance tax implications around gifting, either outright or into a trust, and the rules around deliberate deprivation of capital. So if a local authority believes that someone has given an asset away deliberately to avoid it being brought into that assessment, they have the power to be able to still assess the person as owning that asset. And these rules are not time limited at all. In reality, I've been asked if using a life rent trust, it's only the house that's used, not money included. It's entirely up to the testator who's writing the will as to what goes into the life rent trust. The house is one that's commonly used simply because, in practical terms, It's an asset that the survivor really only needs as a place to stay. If you put cash assets into the life rent, then the survivor might not have access to those cash assets as capital. They would have access to the income from them, but particularly in current times, that income might be quite modest. So it really, there can be a discussion about that, obviously, but it really depends on the view within the couple, within the family, as to how much cash the survivor might realistically do without in those circumstances. I've also been asked what number of years won't a local authority look beyond when assessing deprivation of assets. There is actually no single answer to that, and it does vary from local authority to local authority. In East Lothian, I would probably say that they basically don't have a lot of resources to investigate this beyond 6 to 12 months, something like that. But I have to be clear that that doesn't mean that they can't. And we are aware that, particularly south of the border, that some local authorities are employing people specifically, I think they're called deprivation agents or something like that, employing them specifically to look into this in order to save the council money by finding out if someone has given away assets. So as I say, the longer the period between giving away assets and asking for help, the better, no doubt. And best of all for it to be in years rather than months would be my view. Okay, I think that probably is us then. We're at 8:30. Oh, here we go. Can you appoint, sorry, another question. Can you appoint power of attorney to A whom failing B? Yes, you can. It can be A whom failing B, it can be A and B whom failing C, it can be A whom failing B and C. It is really up to the adult as to how they want to structure it. It's worth thinking about, if you're appointing joint attorneys, it's worth thinking about the potential relationship between them. They do have a duty to report to each other, but it's probably sensible not to go into a situation with your eyes open where you know that they're going to be at loggerheads with each other. So that's why I say, thinking carefully about who you appoint as your attorneys is an important part of the discussion. But absolutely, you can have substitutes, and the substitutes would only then be able to use the powers when the principal attorney either dies, resigns, or themselves becomes incapable of acting.